Hello, and welcome to Season 1, Episode 10 of ARBinBRIEF, a practical video guide on hand-picked arbitration issues. I am Nadja Harraschain, and I'm one of the founding members of ARBinBRIEF. ARBinBRIEF videos, in collaboration with ERA-Pledge, Delos dispute resolution, and Mundi, offer a quick resource to consult on issues that arise in international arbitration, while showcasing at the same time talented arbitrators in an interview format. Over the course of 10 episodes in the first season, we moved through the life cycle of an arbitration. Today, we end our first season with an episode on taking enforcement risks into account when drafting the final award. I am very honored to introduce to you our arbitrators. Joining us from Belgrade today, our interviewee is Senka Mihaj, founding partner at Mihaj, 𝗔𝗥𝗕𝗙𝗏 Law. And joining us from Sao Paulo, our interviewer is Adriana Braghetta, founding partner at Adriana Braghetta For those who are joining us live, the 15-minute interview will be followed by a 15-minute Q&A. Please send any questions through via the Q&A function. During the Q&A, anyone who wants to will be invited to turn their cameras on, and we encourage you to actively participate. Now it's over to you, Adriana and Senka.
Thank you very much, Nadja. It's a pleasure to be here. It's a pleasure to interview Senka in this interesting topic. So Senka, let's start by having a look at the wide-known, recognized New York Convention. We all know about it, and I imagine that the attendees also are pretty familiar with the New York Convention. Would you say that the arbitrators are on a safe side when it comes to the risks they should take into account when considering the enforceability of the awards under the New York Convention?
Well, unfortunately, no. The fact that almost all countries in the world indeed ratify the convention does not mean that the tribunal's task is simple when it comes to consideration of the risks of enforcing awards in these countries. The convention recognizes at least two reasons for rejecting the enforcement that brings uncertainty when it comes to the question whether the enforcement of the particular award would be uncontroversial, and these reasons are non-arbitrability of a particular case and the breach of public policy. Indeed, in vast majority of the arbitration cases, arbitrability and public policy would not even come into play as they concern to simple commercial matters, such as sale of goods or product quality. And countries that are signatories to the convention are in agreement that these matters are arbitrable. Also, when it comes to public policy, as long as the award in these commercial disputes is in line with mandatory norms and most basic notions of justice and morality, the risk of its non-enforcement is just, I would say, a theoretical possibility. However, there are some cases that inevitably trigger the tribunal's deeper and more serious consideration of the enforcement country's public policy. And this is precisely where I see the risk that the arbitration could overlook the existence of the reasons that could lead to non-enforcement of the award. And while it is generally accepted that fundamental economic, religious, social, and political standards represent states' public policy, this unfortunately does not make the tribunal's task any easier, as it could differ from the state to state whether a particular standard represents public policy or not. And not only that, but it would be of no surprise that in one state, the same regulation is understood differently among practitioners as a public policy norm and the opposite. The problem would be much easier for the tribunal if it could simply rely on the mandatory norms of the enforcement country. However, it is undisputed that there is no sign of equality between the public policy notion and mandatory norms. In other words, the tribunal task to determine whether public policy of a particular country would be an obstacle for the enforcement of its award may be very, very demanding. However, often there is let's say, the light at the end of the tunnel, and that is the case law. For example, thanks to a number of available court practice, the arbitrators can recognize with no trouble that the lack of their independence and impartiality will almost certainly represent the breach of public policy and thus the impediment for future enforcement of the award. And also having in mind the accessible practice, arbitrators dealing with the case that involves civil law jurisdiction should have no problem in recognizing that the award granting punitive damages would be considered as contrary to the public policy and thus unenforceable in this jurisdiction. Likewise, it is common knowledge for arbitrators that the social and religious environment of certain states imposes some specific rules that might represent the risk of enforcement of the award. And one of the examples would be excessive interest in the Muslim countries. Finally, what can certainly not be disregarded in cases where the enforcement is likely to happen in the EU member states is the risk of non-enforcement in matters involving consumer and competition protection. To assess and avoid these risks, arbitrators will have to take into account the practice of the EU Court of Justice, which proclaimed that these issues fall under the public policy of EU member states.
Later on, we will discuss a little bit further. I think what is very important is which is the responsibility of the arbitrator to take into consideration the enforcement countries or the seats. But prior to that, explain us a little bit about the arbitrability. If the arbitrators should take that into account as well.
Well, when it comes to arbitrability, there have been very few publicly available cases in which the courts have declared enforcement of awards based on this ground. In particular, the practice shows that arbitrators should pay more attention when they are dealing with a certain type of disputes. For example, insolvency, competition, family, or employment law, since they may not be arbitrable in some jurisdictions. And it was very interesting for me to see that the French law, which is one of the most friendly regulations when it comes to arbitrability, does not treat financial family law matters as arbitrable.
It's interesting, just a brief comment on this. Sometimes, imagine that we are nominated as arbitrator in a case that involves, for instance, insolvency in a possible jurisdiction that it will be enforced is not arbitral. What should we do? I would say that, first of all, we should decide the case. But let's discuss at the end of this episode those risks and which is the responsibility, the final responsibility. The other possibility will be the arbitral tribunal just say it's a non-arbitral dispute in such country. Let's say and see. So tell us your conclusion. In terms of taking into consideration the enforcement risks. They are too demanding for arbitrators. What's your opinion on that? Senka.
Well, I think that it is important to firstly note that many arbitration rules do not contain an explicit provision demanding that arbitrators take care of enforcement of the award. However, one of the most popular arbitration rules, ICC arbitration rules, oblige the tribunal to take every effort to make sure that the award is enforceable at law. And arbitration rules of the Stockholm Chamber of Commerce, as well as the rules of Serbian arbitration institutions, for example, contain a very similar provisions. On the other hand, LCIA arbitration rules provide that not only tribunal, but also the LCIA court and the parties shall take every reasonable effort to ensure that an award is legally recognized and enforceable at the arbitral seat. But however, regardless of the applied arbitration rules, the arbitrator's job is undoubtedly to reach an enforceable award. So enforcement risks are thus not only incidental question for arbitrators.
Okay. One comment to my side is that at ICC, for example, I think that one of the greatest and features of ICC is to have a large group of people participating in the court. So whenever you have a Serbian case, or whenever you have a Brazilian case, you have someone from that jurisdiction inside the court. And this person will be able to help the institution to say, you know, pay attention to these mandatory rules that exist in the seat of arbitration. And this probably this is the right moment to say there's a huge difference between the seat that was chosen by the parties and also and the other possible jurisdictions that the parties will try to enforce the awards. So, and Senka, are the arbitrators obliged to take any efforts to avoid rendering non-enforceable awards? Or are we talking about the reasonable efforts? And if it is a reasonable effort, what would that encompass?
Well, actually, the question how deep the arbitrators should go in analyzing the enforcement risks is a bit more complex, if not theoretical. What is, however, widely accepted is that arbitrators must pay attention to the first leg of reasons for non-enforcement of awards from Article 5.1 of the Convention, and these reasons all relate to manifest violation of due process and gross deficiencies of the rendered award, and are basically the reasons why the award could be set aside in the arbitration seat. Needless to say, these reasons are thus inevitably important when assessing the enforcement risks. As for the second leg of reasons from Article 5.2 of the Convention, arbitrators' task would be more demanding, but I would not say that it is impossible. And although arbitrators could face controversies when assessing the arbitrability and public policy, the fact is that the majority of possible stumbling blocks is already well known in the arbitration community. However, another practical problem for the tribunal lies in the fact that it is sometimes very controversial where the enforcement would be pursued. And it goes without saying that it would be proper to demand from the arbitrators to put themselves in the shoes of investigators and inspect where the award could be enforced. So the parties' input in that regard seems as necessary. Of course, the parties, unlike the tribunal, are the ones who are aware of the possible places of the award enforcement. LCIA arbitration rules that I already mentioned obviously recognize the said problem and explicitly provide that the award should be enforceable at the arbitral seat. And one more important thing, they also predict that the parties also have duty to make reasonable effort to ensure that the award is enforceable. So the arbitrators acting upon these rules thus have no dilemma as to, for example, what public policy they should consider. And of course, it is equally important and helpful that the parties are explicitly obliged to help the tribunal in identifying the enforcement risks in particular case. At the end, I think that it is also worth noting that the award rejecting claimants' claim based solely on the assumption that such an award would be non-enforceable would be an exotic endeavor. It does seems that the arbitrators rather leave the courts of the enforcement country to decide whether the particular controversial situation is such that it must prevent the enforcement of the award.
I totally agree with you. I would add that when we sit as arbitrator, our role would be, we have to take a lot of consideration of the arbitral laws at the seat and the case law. Sometimes we may take into consideration possible places that these parties will try to enforce, but you know, it's impossible to imagine, and it's part of the game. If you cannot enforce in one country, you go to another country and try to enforce it. And the parties know that this is part of the game, and they should also pay attention when drafting their agreements to have guarantees in possible places where they will enforce the award. So a final question to you, Senka, would be in relation to the role of the parties. You mentioned that the parties have a role in helping to foster the enforcement of the awards. What else can the parties can do in that sense, please?
Well, actually, the Delos rules contain, I would say, an innovative provision in that regard. In particular, under Article 16.2 and Appendix 6 of the Delos rules, the parties agree that one party may apply to Delos to publish a compliance failure notice if the other party fails to comply with an award. And this notice includes, among others, the names of the parties and the dispositive section of the relevant award that has not been complied with. So I think that agreeing on application of that mechanism could definitely improve the chances for enforcement.
Okay, thank you very Senka. Thank you very much. Back to you, Nadja.
Well, thank you very much, Adriana and Senka, for this incredibly insightful discussion in which we learned a lot. In particular about whether arbitrators should enforcement risks take into account when rendering the award, and to what extent they should do so. So at the end of our episode, we would like to thank our partner organizations ARBIPLEDGE, Delos Dispute Resolution, and Mundi for their invaluable support. Delos Dispute Resolution is an independent arbitral institution established in 2014. Mundi provides arbitration research tools for lawyers, including a directory of more than 5,000 profiles with arbitrator analytics. The ARBIPLEDGE establishes concrete and actionable steps to increase the number of women appointed as arbitrators with the ultimate goal of full parity. We are also happy to say that ARBINBRIEF Season 1 is supported by ArbitralWomen, Careers in Arbitration, and the Rising Arbitrators Initiative. For those of you who are watching us over YouTube, our video ends here. Thank you for joining us. To see future brief videos on hand-picked arbitration issues, please follow us on LinkedIn and like and subscribe to our YouTube channel. We would also love to hear your comments and feedback, and you can register for our next episode on www.arbinbrief.com.